Anna. I'm Colleen Utz. I'm a paralegal here at Alaska Native Justice Center, Inlet Tribal Council Victim Services. And I'm going to talk to you today about domestic violence protective orders and help you become familiar with the forms and then what constitutes domestic violence and who can file for an order of protection and how they work. So first, a little information on domestic violence. Domestic violence is typically when one person maintains control and power over another in a dating, marital, or live-in relationship. The means of control can be physical, sexual, emotional, and economical. The abuse can be threats and isolation. Most domestic violence survivors are women, but both men and women can receive and experience abuse and domestic violence. You probably have found your ability to make decisions being taken away by the abuser. If you're a victim with your choices and options have been removed, the abuser may come to treat you like a piece of their property that they own, rather than as an equal in making decisions regarding your household, children, and other matters. Under Alaska law, it's illegal for another person related to you to hurt you physically in any way, to force you to have sex with them when you don't want to threaten to hurt or kill you or your children, destroy your property, or hurt your pets. Domestic violence occurs when you're physically, sexually, or emotionally abused by another person who's related to you, and that would be as in what I described, a former spouse or a current spouse, a person that you've dated or are presently dating, a person with whom you've had sex, a person who lives or previously has lived with you in the same household, a parent, step-parent, grandparent, child, grandchild, aunt, uncle, cousin, second cousin, or children, or any of these kind of relationships. So physical abuse is physical force to cause you pain or injury, and it can involve kicking, biting, slapping, pushing, punching. Choking is typically how strangulation is referred to, but strangulation is the proper term for someone cutting off your airway, usually with their hands or some type of restraint. Restraining or confining you using a weapon or object to harm or injure you. Sexual abuse is forcing someone to participate in unwanted sex, performing unsafe or degrading sexual activities, limiting someone's sexuality and reproductive choices, forcing someone to look at pornography or participation in unwanted acts. And emotional abuse is not considered domestic violence under the law, but there are certain instances where emotional abuse that causes harm or fear can be considered to grant order of protection. So emotional abuse is the use of words and actions that are threatening, intimidating, or scaring you into doing what someone wants you to do. It can involve threats to hurt you or your family, the abuse of your pets, threats to take your children away from you if you leave, destruction of objects important to you, depriving you of money, sleep, affection, harassment at work, name calling, making fun of you, and other verbal abuse. Emotional abuse is perhaps the hardest to detect, but it's just as serious as physical abuse. So here we have a petition, and this is, most of you may be familiar with it, maybe not, but I see them regularly in the line of work that we do, helping people file these in court and then helping them gather their evidence and presenting it in front of the court. So initially, one would file a petition for domestic violence protective order, and this is for one petitioner. There is a petition for multiple petitioners, like if you have children, you can include them. It just extends this portion with the petitioner being multiple people that you fill in. So at this point, you can apply for a 20-day protective order, which is considered an ex parte protective order, which basically means that it is necessary to have the protection without notifying the respondent. That's the one who's committing the domestic violence, because of the emergency type circumstances for protection. And so the other party is not notified. It doesn't have to be notified of filing this. And the court can grant a 20 days, what they call stay away order. And during that time, it's considered a cooling off period between the parties. And then if a long-term protective order is wanted or needed, this box here can be checked. And this is granted, a request for a 1-year order of protection. And that begins from when it's granted, not from this 20-day, or when you initially filed this 20-day protective order. So a hearing for the long term would be set out after this order is given for 20 days. And then during that cooling off period, so to speak, law enforcement serves the other party with the notice of hearing for the long-term protective order. And at that proceeding, that's when you need to file your evidence or to bring your evidence to court with you. And evidence can be pictures of what has occurred as far as damages or injuries, bruising, broken doors, windows, objects, and again, injuries, any type of injuries. Can be medical records as well, of any medical assistance that you've sought. And all of that can be brought to your long-term protective order hearing. And you just bring a copy for the other side, being the respondent. And they may show up and they may not show up, but as long as they've been served, the court will go forward with this long-term hearing. If they have not been served, and law enforcement will typically file with the court a notice that the other party has been served. Proof of service is called. And if the other party doesn't show, typically this is just granted by default. If the findings are there that this relationship exists between the parties, that a crime of domestic violence has occurred, and that the order of protection is needed and wanted by the petitioner. And so that's when, at the point after evidence is presented, the court makes a finding in these areas that all of the requirements exist and by what relationship. And then when this petition is filed, this is where you fill in the incidences that occurred between the parties that caused you to file the petition. And the incidents usually start with the most recent, moving backwards to the most 3 recent events. It doesn't matter when domestic violence has occurred. If it's in the past, one can still file for an order of protection as long as there's still, the relationships have occurred or still exist, and a person is in fear or being harmed or threatened in any way. People don't always immediately file for protection. Sometimes they think the incident's over, and then maybe the other person comes around and is menacing or threatening in some way, or so, they choose to file an order of protection because they feel that they're in harm's way again. So the time frame that the incidents occurred does not matter, and so anyway, moving on in the order of protection, you want to state whether or not a weapon was involved. This is important because if there was a weapon involved, you want the court to order them not to use or be in possession of weapons while the protective order is in effect. And then if someone was injured, you want to describe that, and then also have either your own testimony is also evidence, but maybe a witness or photos or a medical record to show that injury. And even some people journal and stuff, even that is considered type of evidence. Has the respondent been involved in other instances of domestic violence with you as the petitioner or anyone else that you know of? Typically, unfortunately, people who have a history of domestic violence continue to offend and commit domestic violence on future or current partners, and they typically have past partners that they've committed domestic violence upon. So that's important for the court to know. Protection that is requested, here you want to check the boxes that you don't want the respondent contacting you. Definitely, this one's already checked because the court's going to order the respondent not to threaten or commit domestic violence acts, stalking, or harassment upon you. Here, this is not checked because there are certain exceptions that you can have contact through. Typically, when people have children, the court will allow them to have contact maybe through their attorney or email. It just depends on how volatile the domestic violence is and how much the person is in fear of their partner or previous partner. And then the respondent is to leave and stay away from where the petitioner lives. That's typically always chosen. And does the respondent live with the petitioner? If they do, usually one of the parties have to leave the home, and typically it's the respondent. And does the respondent know where the petitioner lives? This is important because if they do, then maybe you want to keep that confidential. And then there's a form that goes with this, but also they'll keep track of that in the file if you check this box. And then respondent to stay away from and not telephone or contact any of the following locations. These are usually, the usual places that people are at, their school, their job, their children's school. A&MC is always a big one on here for us. It's like, if somebody has an appointment there and another person has an appointment, what happens? Well, it's the respondent's duty to walk away. The petitioner just goes about their business, and it's the respondent's duty to walk away. If they don't, then they're in violation of the contact order, the petition protective order, excuse me. And then exceptions would be, I've seen some people put if they're both at the hospital, then as long as they're staying away from each other and doing their own business, then it would be okay. So the respondent is not to enter, follow, or interfere with operation of any vehicle occupied by the petitioner or in the petitioner's possession. That's an option. Respondent not to possess or to use controlled substances. And this is typically checked if substance abuse is an issue in the relationship or while the abuse has occurred. We see that a lot. And then the court can order that they take a substance abuse assessment or stay away from places that serve alcohol and things like that. They'll make special orders concerning controlled substances. And then to give the petitioner temporary possession and use of the following items, regardless of who owns them. And here's where the residence comes in. If the petitioner is at the residence and the court parse out what things the respondent can take from the home. And then usually the peace officers will stand by while they get a few things. They usually give them a few minutes to go in and take some of their possessions. And then the petitioner will have control of the home until the protective order runs out or until they give, provide a date or that it expires. I've seen instances where one party owns a home and the petitioner has filed a protective order, and so the respondent has to leave, but they're still making mortgage payments, and so they'll give the petitioner time to get things situated financially or whatever so that they can, get their own place, and then after that takes place, the respondent can return home. And then same with vehicles. The court doesn't matter who owns it, but the court may award use of the vehicle to the petitioner because there's children involved and they need to get to school or, some reason related to that. And then here we go through all of the essential personal items, and it seems tedious and kind of maybe small, but it is important because you wouldn't believe the things that people, fight over, so to speak. And so all of that is laid out here, especially the things that come up over and over again, like Medicare, Medicaid coupons, food stamps, the pets, that kind of thing, house keys, the garage door opener, because there's ways, and not just for respondents, but there's ways that people toy with each other with these kinds of things. So it's just important that it gets spelled out here. And so all of those things are addressed. And then, the respondent to pay spousal support to petitioner. So typically, if a person has been relying on the respondent to pay the bills and the mortgage and food and all of the things that they depend on, say you have a brand new baby or something, the court wants to make sure that the petitioner is taken care of and that they aren't deprived emotionally by the finances being in one party's hands. So they'll make orders based on that here. If you check this box, respondent is not to sell or dispose of any of petitioner's personal property, any property jointly held by petitioner, or any disputed property. That's if you're in concern of anything that the respondent has in their possession that they might get rid of or sell. And then other requests for short-term protection here. And then for the long-term protection part, basically all of these things are gone over and ordered here. So if at the long-term hearing, the court will go over all of the above and then read through and determine if they should be ordered for the year. And if there are things in dispute, then the court takes evidence on that and then makes an order. So I want to talk about children for a minute because when protective orders are filed and there are children involved, the petitioner will ask that they have temporary physical custody of the minor children, and they list them here. So this is usually filed in district court. Custody orders, not interim custody. Interim custody would just be for the duration of this protective order. But custody order for full time is going to be done in Superior Court. Superior Court has jurisdiction over those matters. So sometimes when this is filed in district court, the Superior Court may then have a party may file a case for custody simultaneously in the Superior Court. So what the court has done so that there are not conflicting orders where maybe the Superior Court judge doesn't know about this domestic violence and what's occurred between the parties, the court will move the district court case in front of the Superior Court, and it's called one family, one judge. So the courts have done this to kind of streamline the cases into Superior Court in front of one judge so that he knows or she knows all of the facts and all of the history between the parties so that they can make an informed decision about what's best for the children, because that is paramount to any of this. What's going on between the parties is the best interest of the children. So that then goes through this part of the protection requests, ask some questions about how long have you the children lived in Alaska, or have they lived in Alaska for the past 6 months? And that question specifically pertains to Superior Court having jurisdiction over the children to make an order about custody. So I hope that makes sense. But and so who has the children now? And then is there already a custody order about one or more of the children? So sometimes that custody case is already filed in Superior Court, and then someone files for protective order. They want to know about that so that they can combine them and get them in front of the same judge. Visitation. If the petitioner feels that the children can visit their father, that none of the violence has been directed towards them and there's not been an issue, or there hasn't been really a history of domestic violence, they can propose visitation to the court, and the court can take that into consideration and may order. Like there's our Family Wizard app that we use, and the court orders often that parents use in order to visit with children. So it's like a FaceTime call in the instance where the court and the petitioner may be concerned about the children's safety. Say it's not necessarily about physical violence, but maybe substance abuse or whatever. So that can all be worked out here, and it can be done safely through a parenting app or supervised visits. And it can also be ordered that not be supervised if the children are older and capable of, notifying someone if they feel threatened or whatever. It can be ordered here. So then child support. This is where the court makes an interim order. This whole thing in the protection order is just going to be for the period that the protective order is in place. Once the protective order expires, these orders expire. And again, that's also the reason why it's put in front of one judge, so that if there are orders that the court wants to stay in place after the protection is over, then they can make those orders continued through the custody case. So one can request that child support be paid, and this is information about the respondent's job and what they make. And then typically we ask people to file an application with Child Support Enforcement Division so that they can receive their payments on a monthly basis on time through the system, rather than it being left in the hands of the respondent. And it's possible that the payments could be withheld or used as a form of controlling the other party. I actually see it all too often. It's a shame, but it does happen. Here you would list other cases where there are open domestic violence criminal cases. So that would be sometimes when there's a DV petition filed, the respondent has committed an act that's against the law, like assault or sexual assault, and the case has been filed with the court, the police have filed the criminal case. And in that instance, you want to list that here. It's not required that there be a criminal case in order to file an order of protection. You don't have to have, they don't have to be arrested or even reported, for that matter, in order to file a petition for protection. So here you list all of the open and closed cases on this part that involve the respondent. And up here, it's involving either petitioner or respondent. Because sometimes we see cases where the petitioner has been charged before, or has a protective order against them, and they are the respondent, and now are the petitioner. It happens. I mean, there's mutual combat that happens sometimes. And in that instance, they wouldn't necessarily grant the protective order against one party or the other. But sometimes there is mutual combat where the police get it wrong and the victim is the actual perpetrator, or vice versa. So they don't always get it right, but we do see, and sometimes they have it right. It's just how it is. So you'll see that sometimes there's cases involving the petitioner as well. And that doesn't prohibit them from filing for a protective order. Everybody deserves to be protected. So assistance from law enforcement, this would help the petitioner, as I was speaking of earlier, take possession of the residence, and then they would stand by while that takes place, and then take possession of their vehicle or personal items, minor children. That's an issue at times where respondent has the children and doesn't want to give them up. Go with the respondent to the residence, which might not necessarily be the place that they were living, but to get their personal effects. So, and then also, the respondent's things may be at the petitioner's home, so law enforcement will notify the petitioner that they're coming, and they're going to let the respondent in for a bit, or the officers will sometimes go in and get specific things, or the petitioner will have those specific things ready for the respondent to pick up. People can't get all of their things during this standby, and sometimes that's upsetting to them, but that's just the way it is. I mean, the police can't wait around, for a long time while people get all their effects. So information about the respondent is going to be their full legal name, their nickname, and then the way to contact them. And that's to ensure that the peace officers can serve the respondent before the 20-day order is up, and so that there's continuity of the order and protection, that doesn't break, so that there aren't windows of opportunity for abuse. Okay, and then this just talks about keeping your information confidential in the file and to the respondent. So you would fill this out here. And true filing is in Anchorage, became available last September. And for some people, it's a little bit challenging. So you can opt out of using true filing. And there is an email for the domestic violence desk at the court. It's on the main page, the home page of the court's website. You can just click on the information and contacts for the court, and it'll give you the DV desk email, and you can email those documents there. Even if you hadn't filed a form to opt out of using true filing, or sign this little certificate here that says they're exempt from using it for one of the reasons listed, they're not gonna turn away your petition for protection because you filed it wrong. They're gonna try to help you and get it filed. So just know that. And you can always call the domestic violence desk as well. By the end of this presentation, I'll give you that phone number for the DV desk. And let's see. So on True Filing, it's a website, and you got to make sure to use True Filing of Alaska. As we found out as we were new to it, this Alaska courts part is really important to put into your search for True Filing, because True Filing is used all over the United States. So you just create a username and password, and then it tells you how to upload your documents and make them into PDFs. So that's the petition. This is a request for service, and for the peace officers to do a return of service. So you would only fill out this top part here, and the court fills this out and hands it off to the peace officer that comes to the court or that comes to get that serves them. Sorry, excuse me. The judicial services are the Alaska State Troopers that serve these, and sometimes APD. And then once they're served, they return this to the court. And that's how we know it'll show up in court view as proof of service. It'll also show up in true filing. And if you're registered with true filing, everything's done by email there. So all your notifications will come by email. If your short-term protective order is granted, it will come to you by email. A PDF of that will come into your email. And you'll have it, most people have it on their phone and have it readily available to show officers in case after that order is in place that it's violated. We urge people to call 911 to report violations of a protective order. And we'll talk about what those violations are here. And that's an additional crime under the statutes. This is a request to modify a protective order. So during the period of time that you've requested maybe a long-term protective order for a year, sometimes even during the 20-day period, someone may file, either side may file a request to modify the protective order. Sometimes this is done by the petitioner if they've had a change of heart, which happens. If they want the respondent to see their children, there are many reasons that someone would want to file this and have the court modify the order. But the only way that anyone can, either side can change any of the original order is to file this modification during the period of time that the order is in effect. And so sometimes it's just, the respondent wanting it dropped, and they're usually denied. So the petitioner often will file them if they, like I said, have a change of heart, and then that's can be done. Okay, so now I'm going to talk about the laws, what constitutes domestic violence as far as the crimes of domestic violence. So under Alaska statute 1866, so it's 18.66.990, the crimes that constitute domestic violence are burglary, a criminal trespass, so that's going into a residence or somewhere where you're prohibited from being or you've been told not to go, and or forcing their way in is considered burglary. Arson or criminally negligent burning, criminal mischief, terrorist threatening, violating a protective order, which is violating any of the terms of the order, harassment, which is unwanted contact, and it after the person harassing has been told to stop, they continue to do so. Cruelty to animals, especially in the instance that the animal is a pet. So interfering with the report, interfering with reporting the crime of domestic violence. So that would be, like taking someone's phone away, or their ability to call for help or get help or to leave. So obstructing their way, something like that. Unlawful contact, that again would be violating the conditions of the terms of the protective order, or just in criminal cases, there's a no contact order that is automatically placed between the defendant and the victim. So as long as the case is active, the criminal case is active, the court has that no contact order in place. And if the defendant should try to reach out to the victim, it's considered a crime and unlawful contact, and it can be charged as crime of domestic violence. Now, any of these crimes of domestic violence have a tag. So in any type of domestic violence case, you're going to see DV. And the reason that's important is because it lets people know that there is a history of domestic violence. And in the instance that there is more than 2 instances of domestic violence, and there's a measure of severity and all of that that goes into it, if there is considered to be a presumption of the act of domestic violence, the statutes that are under the best interest statutes concerning custody, the party who is perpetrating the domestic violence may not have custody under the Alaska statutes until they've completed a certain amount of programs or prescribed by the court. So the court would have to order them to like a batter's intervention program, which involves 36-week state-approved domestic batter's intervention program. So at their own expense, they have to complete these courses over 36 weeks and get a certificate and successfully complete them. And once they file that with the court, then the court takes notice. But if they want a change in custody, they have to file a modification for custody at that point in order for the court to assess everything and determine that they have the ability to have either visitation, it could be supervised still, or it could be partial custody of the children. So it's just really important that DV tag follows the whatever case that there's domestic violence in. If that makes sense. Let's see. So those are the crimes of domestic violence and safety planning. Typically, our agency through our victim services team will help people, our case management people will help with safety plans, and that involves, getting friends and family involved and letting them know about your abuse. It's important, a lot of people don't want to involve their family and friends in these matters, but it helps you keep yourself in check, but it also helps, people keep their eyes open for you, and to let to let them know that you need their help, which is perfectly fine. If the defendant's been ordered by the court to stay away from your home, ask your neighbors to call the police if they see him around near your home. Tell what kind of car he drives. Advise your neighbors so they can watch your house if you're not there. If you have a phone, request that someone call you at least once a day to ask if you're safe. Anyway, so our case managers will go through that criteria and help people form, a safety plan that fits their situation and helps get them, keep them safe along with the protective order. Because, people ask, well, what good's a piece of paper going to do me? And well, it can help a lot if, because they go into the Alaska Public Information System network, which is in the police officers' vehicles. They have access to it, and it will show that there's a protective order in place. Domestic violence is one of the most volatile situations that an officer can walk into. And so they want to know that, there's the potential of violence going into it, and what they could be facing, because not only is it, sometimes a situation where homicide is a big factor, but homicide, suicide can be a big part of, a big concern. So um, the Violent Crimes Compensation, that's an organization through the state that can help compensate for any kind of um, damages, actual damages related to your injuries. Sometimes people have hospital bills, ambulance bills, things like that that they can't pay for, and they can apply to violent crimes compensation through the state to help get help with those kinds of financial burdens related to violence. And Office of Victims' Rights, they are also a state organization put in place by legislature to help folks if they don't feel that their case is being prosecuted fairly, if they don't like, not like what the prosecution is doing, but if they don't think that, attention is being given to their case fairly, or if officers aren't behaving, in a way that they feel are conducive to what, public servants should be doing as far as helping individuals. Sometimes, folks are concerned and feel like they're being blamed for their own victimization. But Office of Victims' Rights is an organization that you can report to, and it's the only organization that has attorneys that can enter an appearance on the behalf of victims if there is in fact something that has gone against their constitutional rights. And we always tell people to call 911 if they feel that they're in fear of their life or in fear of physical harm. And that's about all I have as far as my presentation on protective orders. And I don't know if we have room for questions, but Tatiana, you can let me know.
Yeah, Janan, Colleen, I learned a lot about DV protective orders, and I didn't know a lot of those things. So I really
Oh,
appreciate it, and it was really informative for myself, but I bet it was for others too.
it's my pleasure. And I appreciate you giving me the floor to help. I really enjoy helping. I went through it a little bit fast here, but
I think it was at a good speed for me.
good.
We don't have any questions right now, but if you'd like to close out, that's fine too. Just a reminder to do the post survey, which is in the comments. Thank you, Chanan and Sabrina, for that. Um, but yeah,
Great. Thank you so much, Kayana. I appreciate your time. Mhm.
okay. Thank you, everybody. I think we'll end it here. When I end the webinar, it will direct you to the post survey as well. So thank you for doing that. It really helps DIJ out with reporting and getting grants and stuff like that.